Welcome to Skills to Pay the Bills and today's segment of JustAskFreeman.com. I'm your host, Tia Young, sitting in for Freeman and Carolyn Owen. We have a great show for you featuring returning guest, attorney William S. Fralin, a nationally known elder law attorney, the founder and shareholder of the estate planning and elder law firm, PC, in Arlington, Virginia. Attorney Fralin has represented over 7,000 clients throughout the Washington metropolitan area, in addition to the practice areas of estate and incapacity planning. The firm practices chronic care advocacy, which incorporates staff social workers into the life planning process. Please welcome Attorney William Bill Fralin. Attorney Fralin, welcome back again. It's good to see you again.
Thanks for having me.
Well, thank you for taking away from that busy schedule that you have.
Not a problem.
Good. Well, we're going to get right into it, this very important subject here. And my first question is almost three questions in one. And the first is, first of all, what is asset protection? What does that mean?
Asset protection, see, a lot of people are familiar with the term estate planning. And that's planning for what happens when one passes. But asset protection planning is planning so that the assets that you spend a lifetime building up, if you get a chronic condition, that those assets are not consumed to pay for care, but that they're there and made available for you or your loved one to enhance their level of care and also to make sure that the resources available to their spouse or their children for whatever needs may arise. So we're trying to protect the assets so that we can use them during the lifetime of the husband or wife or individual, and that they're not unnecessarily spent down, which happens in a majority of cases because most people don't understand the rules.
They don't, okay. And so then asset protection, how does that fit into the estate planning equation?
With estate planning, estate and incapacity planning, there's two components. There's estate planning, which what happens when one passes. Who's in charge, who gets what's the manner in which they get them. But the other side of the equation is incapacity planning, which again, everyone over 18 should have that. This just says if I can't make a financial decision, I'm going to select, now that I'm healthy, who's going to do that. If I can't make a medical decision, I'm going to select my spouse, my brother, my sister, my daughter to do that, because if I don't have those documents in place before anyone can act on my behalf, the only other alternative to the powers of attorney, those two documents, is to go to court and have a guardianship. It's a huge waste of time, a huge waste of money, and it's an adversarial proceeding where you may be on the stand testifying against your mother regarding her competency.
Right.
So the far easier route is to do your power of attorneys, say that you can take whatever actions are needed on my behalf, including asset protection planning, which is a specific subcategory that says if Bill has a chronic condition, the power of attorney lets me take whatever actions the law permit. The laws are very complex, but in every case where there's long-term care costs involved, you can save between 40 to 100% of the assets for the purposes, as I said before, of getting good care, which is our primary goal.
Right. Now, you mentioned the 18-year-old, and when you said that, I'm thinking, gosh, how do you get an 18-year-old to sit down and think about,
Well, it's funny that you mentioned that, Tia, because around the holidays, parents will send the children in to get powers of attorney, because now, if they're off at college, for example, you can't talk to their doctor, you can't see what their grades are without a power of attorney. So most of the parents I encounter are saying, if I'm going to pay the bill, I'm going to get to see, I'm going to be able to talk to the doctor.
So is that the secret, getting a power of attorney?
A power of attorney is a document where you say, I grant this authority to you. So if you have a kid in school and they're over 18, because a lot of people say, look, I don't have any money, and why should I worry about this? The point is if you have a medical accident or a medical emergency, or if you need someone to act on your behalf financially, this is the authorization. This grants the decision-making authority, saying I have named Tia to make my decisions, and you present it to the banks, you present it to the healthcare providers, and then they say, okay, clearly you're the authorized agent, and then you can take whatever steps are appropriate based on the facts as they are at that time.
Okay. So to me, it sounds like this is a smart decision that people ought to be doing. Talk a little bit about why this is a smart decision.
Well, I tell people, particularly middle-aged people such as myself, I'm 55, is that you need to have these for yourself, you need to have these for the kids, but most importantly, you need to have it for your parents. Because if mom or dad has a fall, has a slip, has a break, breaks a hip, breaks an elbow, in order to talk to their doctors or to manage their funds or pay their bills, without those documents, you will end up in court, and there's 3 lawyers, one for mother, one for you as daughter, and then one for the court called a guardian ad litem. And they will have a trial to determine if mother is competent. And that's where you may end up having to give testimony against your mom. Huge waste of time, huge waste of money. It's a default. The state says if you haven't taken the time to do your power of attorney, this is the consequence you'll suffer. So by taking the time, and it's not that hard, you get a power of attorney, you put it in place, and with the other documents, and you do your estate planning, you usually do it all at the same time. Then it's just a matter of if and when a crisis occurs, the decision-making authority is already in place. And so then you just simply access the options that make sense at that time.
Okay.
The alternative is going to court and adding more stress to an already stressful situation.
Right. So some people may say, well, I already have an estate plan in place, but they still need to take it a little further, right?
Well, an estate plan, a lot of people have a will and say, I've got an estate plan, I don't need to worry about that.
Right.
Wills only take effect when you die. And a lot of people don't know that. And powers of attorneys are only effective while you're alive. When you die, powers of attorneys end.
Yeah.
And so one is for estate planning, the will or the trust, which says when bills happens, here's who's in charge, here's who gets what. And the power of attorneys are Bill's alive, but he can't pay his bills, he can't tell the doctor what his preferences are. So I would give my spouse, my adult children that authority, and then they would interact with the facilities and say, this is what's appropriate, or this is what my dad would have wanted, and without having to go to court and waste that time and waste that money and add all the stress to the process.
Right.
So both sides of the equation, the estate planning and the incapacity planning, I mean, as mortals, as sooner or later, we're going to all need both of them.
Right.
And it's just a matter of will you be prepared or not. And if you're not, unfortunately, it creates much more stress. The costs are much higher, and the emotional costs are much higher. It's far easier to be prepared.
Right. You just said something that is a buzzword to me, that word prepared. In your professional opinion, would you say we baby boomers are prepared? Are we prepared?
Tia, the numbers are staggering. The overwhelming population is, I think the numbers is something like 70% of the population has nothing.
70?
70% has nothing in place. Now, and again, this is the ultimate area of procrastination. Do I get my shirts from the cleaners today, or do I do my estate and incapacity planning documents? Well, the reality is probably you're okay for today, tomorrow, the next day. But the point is that people put this off, they don't address these issues, and then when and you might actuarially, you're probably okay, but if it happens to you, the numbers don't mean much.
Right.
And again, taking the hardest step is just starting the process, because once you start it, you get your drafts and you go through it, and then it's done, and then your family has authority. They can take the steps that are appropriate. And also, too, the rules are very favorable for protecting assets if you have this authority. Yes. If you don't have this authority, if mother has a stroke and has to go to the facility, in order to do the different asset protection planning that's available, you have to go to a judge and get authority to do this planning. Yeah. With a power of attorney, you build it into the document saying if and when this contingency occurs, we can do whatever we need to do.
Okay, so do you think the reason people overlook doing this or doing it early enough is that they think they can't afford it? Because I've talked to some people, they say, if you go to a lawyer, you're gonna have to mortgage your house, and in order to, and
In fact, the reality is that most, a solid estate plan is you're going to pay less to have the will, the powers of attorneys done than if you don't do it and you go to guardianship or probate, you will pay 10 times as much. And secondly, too, it's not just the money, it's getting the relationship with an experienced attorney so that if your husband's having a stroke, you can call and say, what do we do? Where do we go? I mean, and so that you have, because the do-it-yourselfers, legal Zoom I call legal doom, because if my wife's having a stroke and I get on the internet and type, they're like, Bill, we'll be back with you within 24 hours. And having someone local who can say, here are the resources, and intercede on your behalf, that's, in addition to your documents, you have someone to stand behind them to make sure if a hospital balks at it, if a bank balks at it, that someone to force their hand and say, look, this is properly executed, you must take it and you must honor their wishes.
Right. Well, in the introduction that I gave of you earlier, we mentioned about you having social workers on staff.
Correct.
That, I've never heard of that before. Talk a little bit about something.
The first attorney in America, and his name Tim Tekes, who's out of Nashville, was in 1992 was the first American elder law attorney to put social workers on the staff because we got very good at protecting assets. But we found that if we're not getting good care, if I save your mother $1 million and she's not getting good care, can you sleep at night?
Right.
So you really, one without the other is not of a great value. Right. So having a social worker there on staff, if someone falls ill, I send her out.
Oh.
And they assess your mother and say, okay, mom needs either independent, assisted, skilled, but where do you work, where do you live, and here are 3 places to consider. Because there's over 1,000 in the area, but again, they all figured out to put up nice wallpaper, and they might be a good facility, they might not. But the social workers who are in the care circle and have years of experience can say, this is a good place. This, and also, too, the social workers are there for point of advocacy because the greatest indicator of the care your loved one gets is advocacy, is family, professional advocates being involved to make sure that your parent gets the care they're entitled to. Right. Because mediocre care is rampant in the long-term care industry.
Right.
And the people that get the best care have the support networks and have the professionals saying that we will not accept less than quality, consistent care, and this by having the social worker who can interact, having the RN who can review the records.
Review the records, right?
It helps them to focus on their task, which is to give good care.
Good. Well, we're going to take a short break right here. We'll be right back, and when we come back, we're going to talk about process a little bit.
Absolutely.
Okay.
Sounds great.
We'll see you real soon.
Thank you. Hi, I'm attorney William Fralin with the Estate Planning and Elder Law Firm, and I wanted to talk to you today about putting together your estate and incapacity plan. The majority of Americans have no plan in place, leaving their families vulnerable to having to access the court system if they fall ill or if they pass away. Getting the basic documents in place, which include the estate planning documents, a will or a trust, or the incapacity planning documents, which are powers of attorney, one for finance, one for health care. Having those basic documents in place is important for everyone from age 18 to 100, because with these documents you say who is going to act on your behalf, what authority they have, and if you're unable to make decisions, it authorizes them to make decisions for you based on what your wishes are. So it's for your future. And also, too, if you have aging parents, it is critical to at least get the powers of attorney in place so that if they're not well, you can act on their behalf without the need of going to court and going through a guardianship. So the basic planning documents, everyone over 18 should have it. We strongly recommend that you speak with an elder law attorney. Get this put in place for yourself, for your family, particularly for your aging parents, so that that the plan will work effectively for them and for you. Thank you so much for your time and attention.
Thank you for rejoining us as we continue our discussion on creating estate plans for living and long-term care with attorney Bill Fralin. Attorney Fralin, let's talk a little bit about process. What would you recommend people do to get started, to make that first step?
The first step is to contact an attorney that primarily works in the areas of trusts, estates, and elder law. And how the process works is usually there's a meeting where you sit down and you say, here's my situation. I'm single, married, kids, no kids. I live here. And they get basic information. And with that, they can the attorney will ask you about, well, tell me what how would you like this to work? Who do you want to be in charge? And who do you want to be your beneficiaries? And they'll say, too, these are not honorary positions. If you want to honor someone, give them money. This is an administrative position, so you pick the people for their ability to complete the task. And then you do a draft of all the documents, and so you read through it so that you can say, let me make sure I understand this, and also that you can change it and tailor it to whatever you like. So the first step is to make the appointment, and most practitioners don't charge for initial consultation, and they say, tell me, and then you can have your options, and then most practitioners have gone to flat rate fees, which is what we are, which is they look at the assessor situation and say it's X. So you have a solid number and you're not on billable time. Okay. And it should be comprehensive so that you're covering both death and disability, which we talked about earlier, the wills, the trusts, the powers of attorney, healthcare, finance. And then once you get the drafts, go through it, get it to final, you sign it, the law firm keeps a copy, you keep the originals. And then if there's any changes, life changes, then you simply adjust your plan as you go through. Or if you're not sure what to do, you contact the firm and say, here's what's going on. I'm moving to another state. I'm getting married. I'm this, that, or the other. And then they can say, here's some things you may want to consider for your plan so that you know what your options are. Because a good practitioner is going to say, here are the options you have, and based on what you're trying to achieve, I think these are the options that work best for you.
Wow. Now, you said earlier that 70% of the elder population is really ill prepared, for long-term care. So what if I'm somebody and, I'm 55 and I'm just getting a brain charge that maybe I need to do something? Is there any hope for me? I mean, are there things that I can do?
Absolutely. And I have people come in the office say, I feel so bad. I said, look, I'm not a priest, but I can get rid of the guilt if you just sit down and just give me some information. Yeah. But the fact is the bar is very low. If you still have a pulse and you're competent, it can get done. And again, and generally, it doesn't take a long time. Generally, you get documents within 10 days, drafts, and you can review them the same day and execute thereafter. It's just the inertia from starting the process, which and that's why I encourage people, just take the first step, go in and get the information, and make sure, and then understand what your options are, because again, this applies to everyone across the board, young and old. And you have your own preferences, make your own decisions. The law lets you do that. But if you fail to make your plan, they have a thing called intestacy, which means the state of Maryland, Virginia, or the District of Columbia have made a plan for you. You won't have any input, and it may not be consistent with your wishes.
Wait a minute, they make a plan for you?
Intestacy, every state has an intestacy law, which says if Bill doesn't have a will, then we're going to say by degree of kinsmanship, your family relations, this is who will get his estate.
Oh, okay, I see.
Because they have to have a default, because the state says if there's a house and there's no one's name and they're not paying taxes, we as a jurisdiction aren't getting paid. So they have an interest in getting it distributed. So they say if you fail to act, we're going to act for you, but you don't get to pick who's in charge. You don't get to pick who will receive your assets. And most people say, well, I absolutely know who I want to get it, and I absolutely know who I don't want to get it. And so if you have a plan in place, then they have wills and trusts for a reason. They will hold sway. They will be give full force and effect. So you can say, this is what I want done. And at a later date, if you want to change it, you can.
Okay.
At any time.
Okay. So now I've called you on the phone. I've made that appointment.
Sure.
How much paperwork am I going to have to? I mean, what kind of work are you going to ask me to bring to that first meeting?
Most practitioners, they're going to get the name, your name, address, phone number, the name of your close family members, and of who's going to be in charge if you're not well, and who's going to be your beneficiaries. If you pass, who are the beneficiaries of your estate? And you may not even know that now, but the process is designed to elicit that. So if we get in and we're not sure, you're like, Bill, I haven't thought about that. I'd say, well, okay, we're going to leave a blank in your documents. So then when you get your drafts and read through, it's like a computer prompt to say, I need to pick somebody for this. And that's where an experienced practitioner can say, well, tell me about your family, or tell me people, who do you know, who in your life you know and trust, and can say that might be a good choice.
Right.
And so it helps in the process by once you're started, because having done thousands of documents, you can say, well, here's what other people have done. You may like this, you may like something else. Because there's no one size fits all. It's what's tailored to your specific situation. Right. And then that is adjusted over time so that as things change, here's what we're doing today.
Right.
We're just keeping it updated.
Keep it updated. Now, I know we keep going back to costs and to money.
Sure.
But I've been told that long-term care is extremely expensive.
Well,
are there strategies or ways that we can pay for it?
Long-term care is when people are living longer, and they're with chronic conditions. And long-term care is care that is going for a chronic condition, meaning, we will not cure whatever. If Bill has Parkinson's, or Bill has dementia, Bill has Lou Gehrig's, those will never be cured. So they are conditions I will have to live with. Now, the problem is that the long-term care costs in the Washington metro area cost between there's 3 levels of care. There's independent, which is you and I, we get up in the morning. There's assisted, where there's a little bit of help to a lot of help. And then there's the highest level is skilled nursing care. That's when Bill needs assistance with 2 or more activities of daily living, then you're at that level of care. That's the highest cost level of care, and the cost for that is between $10,000 and $12,000 a month.
A month?
A month. You could go on a Disney cruise for less. And so it's a staggering cost, and frequently it comes unexpected. Mom's lived in the same house for 50 years. Over the weekend she falls and breaks her hip, and because she has dementia, she can't rehab, so she went from completely independent to skilled nursing care. And even if you've saved and done all the planning you're supposed to, at $12,000 a month, and that's before the add-ons, and they're very good at that.
Add-ons?
Add-ons.
When you
the
say
$20
add-ons,
Band-Aids, $10 aspirins.
Oh my!
Oh yeah, that's the base rate. So they are trained to do additional.
Scaring me.
Well, that's why you do your homework. It's like anything else. If you plan ahead, you get good results. Now, because there's really only 3 ways to pay for this long-term care. One is private pay, where you just write checks. You spend your money. It's called a spend down. The second is long-term care insurance, and that's insurance that says if Bill ever needs the assistance with 2 or more activities of daily living, the insurance will pay for a year, 2 years, 5 years, depending on what your policy says. So that's an excellent way to do it, but the insurance is expensive. The third way to pay are entitlements, and there's essentially 3. If you're a veteran, there's Veterans Administration has a number of programs, and if you have a service-related illness, there's far more programs. But even if without a service-related illness, there are VA programs. So if you're a vet, you check that out. There's Medicare, which pays. They have a long-term care component under Medicare. Under Part A is hospitalization. Part B is doctor's visits. Part C is an HMO model where, for example, Kaiser would run your Medicare benefits, and Part D is your drug benefit. None of those are long-term care. But Part A has a long-term care component saying if you go to the hospital and you spend 3 nights, they will pay up to 100 days of skilled rehab to get you better so that they can stop paying for your care. Because they want to get you the highest level of functioning, so then and the government pays very well for that because they want to encourage you to get better. But the most you're going to get with the Medicare is 100 days. So the final program is Medicaid. And the Medicaid that we're referencing here is long-term care Medicaid. And it's a program that was created in the Great Society, which pays for approximately 65% of all skilled nursing beds in America. And it's easy to see why, because at $10,000 to $12,000 a month, I mean, how long for the average American until you're spent down? And so, and there's a lot of stereotypes about Medicaid, in that it's, you don't get good care. That's simply not the case. Right. The reality is you can get excellent care on Medicaid, and also there's a lot of planning opportunities that Congress created that people aren't aware of. Because in every case that someone needs long-term care, you can save between 40 and 100% of the sick person's assets in every case. And I've had people say, well, my grandmother's been in the facility and she still has some money in the bank and there's nothing we can do. I say, that's not correct. Yeah. There's a lot of disinformation out there, particularly about long-term care Medicaid. And the reality is in every case you can save at least 40% and up to 100%, because the rules happen to be more favorable for married people. Because, see, with Medicaid, they have a 5-year look back, which they ask if you've given away assets in the last 5 years. That 5-year rule doesn't apply to spouses. So if I was sick, I could put in my wife Kate's name, the house's assets, and if I meet the rule, do it consistent with the rules, then I apply. I'm approved. My care is paid for. She keeps her income. She keeps the house, the car, and other assets, and we continue on with life.
Wow. Well, I'm just amazed at the information and what we don't know. I mean, you said things here that I thought I knew a little bit about it.
Well,
but I don't know.
Well, the problem is that there's not a lot of sources of information regarding this area, paying for long-term care. Right. Because the facilities would prefer they make the most money when you pay the $10,000 to $12,000 of your own money.
That's right.
So they're not going to say, by the way, you could do this, this, or this. Yeah. Now, the state of Virginia, Maryland, and the District of Columbia, while you may be entitled to this, they're not going to advertise, if you access these strategies, you can protect some of your funds for your care. They will give it to you if you meet the requirements, but applications are difficult, and many people get denied because they've never done an application. And if they simply made an adjustment, they'd be approved. Right. But that's the way that the states intentionally do this to keep their rolls down to try to contain costs. But again, it's in my mind, it's almost a misrepresentation of the rules, because these rules were created by Congress to help people in this situation. Right,
that's right. Well, listen, we are out of time, but I'm not out of questions. So will you agree to come back for part 2? And you'll be probably interviewing with Freeman and Carolyn. I mean, he was so disappointed that he's not here. But we want to pick right up with this in part 2.
Be glad
and I want to thank you so much.
Oh, Tia, thanks for having me. Absolutely.
Such a pleasure.
Thank you so much.
Well, thank you so much for watching our show today. We hope that you will take seriously the health and well-being of your elder family members and yourself. Today, we are in our 20s, and before you know it, we are 70. Making strategic decisions today is better than waiting until tomorrow. Thank you for watching Skills to Pay the Bills and this week's segment of JustAskFreeman.com.